Toronto appellate lawyer Cynthia Kuehl has the Lerners Appellate Group Top 5 appeals from the Ontario Court of Appeal for the month of June 2013. All right, Cynthia, let's start with Aviva and Lombard.
Sure. The Aviva and Lombard case is about the allocation of responsibility for a claim between two insurers. In this case, there were two parties ultimately found liable as one defendant. Aviva insured one, Lombard insured both. Aviva paid out the excess claim. There was a primary policy that responded to the first part of the claim, and then came after Lombard for the balance. Lombard said no, there had been a previous priority dispute that had been resolved, that Aviva's claim was to respond next. Ultimately, though, the Court of Appeal found in favor of Aviva, holding that Lombard did have a responsibility to contribute half, did so on the basis of equitable contribution insurance law, as well as on the basis of unjust enrichment. And with respect to the priority dispute, it said essentially that related to the single party, and Lombard was on the hook for both. So ultimately, Lombard had to pay half of the excess claim. The second case is also an insurance case. It's the Goodyear decision. And Goodyear manufactures and markets asbestos. It was unable to get any policies, insurance policies, after 1985 because of an industry cutoff. No one wanted to underwrite those risks. In the U.S., there's a case called Stonewall and the development of the Stonewall Principle that essentially says that if you were an insurer that provided coverage before the industry cutoff date, you would continue to be responsible after the industry cutoff date, because Goodyear was essentially involuntarily underinsured. And Goodyear sought to have that applied in Canada because there has been certain insurance policies issued before the industry cutoff date here. The Court of Appeal said no, the Stonewall Principle does not apply in Ontario. It wasn't universally accepted in the U.S., and more particularly with respect to this contract, they were time-limited policies, and it would be unfair to the insurers to have it apply in this case. And finally, just from a public policy perspective, Goodyear was in that business and accepted the risks of asbestos and the business risks associated with that.
Tell us about Ontario College of Pharmacists and Global Pharmacy Canada.
Sure. In this case, the college sought to regulate or essentially police what it saw were certain violations of pharmacy-related legislation as against the respondents. The respondents included an Ontario company that operated a call center in Mississauga, and Pieters, an affiliated Belize-based company, which got Indian-sourced drugs, prescription drugs, and sold them via the call center on its website to American customers. None of the drugs entered Canada, and there was no Canadian customers. Nonetheless, the Court of Appeal agreed with the College of Pharmacy that that these entities were within its jurisdiction and upheld an injunction below on the basis that if you look at a purposive interpretation of the word sale or selling, it included the activities that were happening in Mississauga, and there was a sufficient connection to Ontario to trigger the jurisdiction of the College of Pharmacists. And importantly here, the College of Pharmacists does have a duty to protect the public. The fourth case is actually quite a bit different. It's Peel Law Association in Pieters, a discrimination case where two individuals, a lawyer and an articling student, complained to the Human Rights Tribunal that they had been discriminated against when they were asked for identification by the Brampton law librarian. And the vice chair upheld their complaint in essence. It was overturned by the divisional court, and ultimately the Court of Appeal restored the vice chair's decision. Although there's a number of aspects that are interesting, the key part is it found the divisional court applied too stringent of a test when it required that there be a causal nexus between the ground of discrimination and the disadvantage suffered, noting that although they had issues with the word nexus, the real issue is the imputation of some need for causation, finding that really what you're looking at is discriminatory effects, not intentions or cause. And there's also a good discussion in that case with respect to social science and whether or not it needs to be in evidence. In this case, it was not in evidence but relied upon by the vice chair. So the fifth case is about doctrine of privity of contract. It's Williams Sonoma in Oxford, and in that case, some tenants at the Yorkdale Shopping Centre sustained water damage when, during the course of construction, a vandal tampered with a water or fire hose. They sued the contractor, Ellis Dawn, and it relied, though, in a motion for summary judgment on a provision in the lease that the tenants have with the landlord, where it essentially required the tenants to have their own insurance for water damage, and further said that the tenants were waiving claims against the landlord and anyone for whom in law the landlord was responsible. On appeal, the Court of Appeal agreed, saying that in-law responsible is wider or broader than vicarious liability. It includes legally responsible, and here the landlord was in fact legally responsible because of certain indemnification provisions in the lease. And further, and relying upon the Supreme Court of Canada two-prong test in Fraser for relaxing doctrine of privity of contract, that these were essentially the activities that were being contemplated for in the lease in that waiver of provision. And accordingly, there was a limitation of liability, and the tenants were unable to continue their suit as against the contractor. So those are the 5 cases for the month of June. For details on all the cases and to obtain a copy of our Netletter, it's www.lernersappeals.ca. Thank you.
Thanks very much.